Great.
Now we are. The timer has started. Okay.
Good afternoon.
Good afternoon. Thank you so much for joining me today.
Yeah, thanks for meeting with me. So I just wanted to let you know about something up front. I don't think you have this evidence yet, so I just wanted to make sure I was providing you with all the evidence. The officer did not put the following information in the report, but I interviewed Young last week. So he told me he had between 5 and 6 beers before Thomas came and sat next to him, and that they may have had another beer or two before the fight ensued. And although Young is only 5'8", he's almost 175 pounds, and he told me, quote, he is no lightweight. And he would not say he was drunk. He just said he was feeling, quote, pretty good. And the arresting officer told me that Thomas and Young seemed very drunk. And the medical records were somewhat reflective of that. So I know that wasn't in the report, so I just wanted to share that with you.
Oh, thank you. That's very helpful. That was actually my first question, just to make sure that we were unable to contact Mr. Young. So I'm glad you were able to send that our way. There was another gentleman, I'm not sure that you were able to get in contact with, another witness at the bar who was, his phone was disconnected. We were unable to contact him. I don't know if you had any.
Yeah, we also had the same problem. We were unable to contact him, and his phone was out of service, and he was not at the address he provided us. So I'm of the opinion we should kind of discard that piece of witness. Well, we weren't planning on bringing any witnesses to the stand if we were to go to trial. So I'm not going to take that witness as credible given his comment, his lack of transparency as to where he lives. And
well, if we're unable to identify him, then I would be forced to agree, at least in that regard. Yes. So I'm fine with moving on from that point.
Okay, let's move on from that. Let's see. So I just want to say at the outset, I'm of the prosecutorial philosophy that we need to really think about the victim and what the victim's desires are. And I've spoken with Mr. Young, and he really seems pretty apathetic to this whole incident. He doesn't really care much what happens with Thomas's case. And he will come and testify if he has to, but I don't think he will be upset if there's some sort of guilty plea or cause any problem in that regard. And I think his needs would be met. I also see that your client has prior convictions, and while they're obviously concerning and somewhat serious, I don't think they're related at all to what happened on the night of the incident. I'm seeing it was in his 20s, nearly 20 years ago. And it was shoplifting, marijuana possession, and cocaine possession, which, while there's some substance abuse issues there, obviously, I don't think any of those issues show a pattern that would indicate that your client is of like a danger to the public, or that putting him in jail for a significant amount of time would be in any way helpful to society at large or to the victim.
Yeah, well, it's interesting you should say that, and I do appreciate that background information. Just to kind of lay my cards on the table, because I think we're both here to kind of, find an equitable solution to this, in the interest of both of our parties. My client's, he's trying to avoid any jail time and a conviction. As I'm sure you're aware, he's a father of 3 children. He's paying child support.
I wasn't aware of that.
Yeah, well, he is. That's kind of his situation. Jail, okay. Given that he is an active payer of child support, and he does see the children quite often.
He already served 30 days, yes?
Yes, and that's he has. Let me check my notes. That is correct.
Yes. Okay. But, go on. Sorry.
Yeah. No, that's essentially where we are. Just kind of reviewing if we were to go to trial, and if things don't kind of pan out the way they should today, or we calculate that we have about a 50% chance, just given past bar-related incidents, kind of trials. We have a little bit, depending on the judge, we have about a 50% chance of winning this, we think.
If you're charged with the original
second degree assault, yes, ma'am. On the other side of that, we have 50% plus 1. That's flipping a coin. 7 years in prison, the maximum sentence that the judge is free to instill in situations like this. That's a lot to gamble with.
Right.
So we do have an interest
Yeah, and I
in
think
resolving this.
we're in the same boat in terms, just to speak colloquially, I think we're in the same boat there. I have some experience in the WCL court system, and some of the judges are very reasonable and might consider, being lenient and using their discretion, but others may not. And I've seen that in similar cases. So what I'm willing to offer, and what my office is willing to offer off the bat, is a 3rd degree assault charge, which is a misdemeanor, and it has no minimum sentence. And the judge can give as little as time already served, community service, a fine, restitution, or probation up to 5 years. And it has a maximum sentence of 1 year in jail, but we will not be asking for jail time. That's kind of like where my head was at. So I just wanted to get your thoughts on that.
Yeah, absolutely. And I appreciate we're on the same page, at least as it pertains to incarceration.
Mm-hmm.
That is kind of a non-starter, at least from my client's point of view, given the situation with the child support.
In my opinion, is this isn't a felony crime. I think this was a bar fight. And I think, so I don't know if you probably, so your client is claiming that he thought he was going to be hit first. Is that correct? And so
yes, we are operating under in the interest of full disclosure. We think this is a pretty cut and dry case of justification. That's, in situations where people are, to the point of being inebriated that they can't remember what happened. Certain emotions do fly, and there are situations where self-defense or, justification is necessary. That's kind of our case going forward. But we understand that bar fights are bar fights, and there are other.
I can concede that. I can understand that your client, reasonably in a very inebriated state, may have believed or misinterpreted the situation to think he was going to be struck in some way. I think the problem I foresee you coming across at trial is there are no witnesses, and it will be hard to say that your client's behavior was proportionate to protect himself or protect him of whatever harm that he thought was going to come upon himself, especially given the alcohol involved and lack of memory and lack of witnesses. So that's my position.
Okay, and I would, and there's a counter offer I'd like to put on the table, but just in the interest of being upfront, the only memory here I think that isn't at issue. My client is willing to testify that he does remember this situation as it occurred. If I have my notes correct here, Mr. Mark Young has no memory of the incident because of the effects of the alcohol. Is that correct?
He, let me review my notes briefly, but he says it's all a bit fuzzy. That's a quote. But he feels very bad, or I'm sorry. Your client, I have that he made a statement to police that he was pretty drunk, and so everything's a bit fuzzy, and that he doesn't recall.
I'd say we're both. Well, I suppose maybe I'm the one who's a bit fuzzy. Needless to say, everyone is. It's a bar fight. There's going to be a lot of lapse between both clients.
Okay, that's what I thought.
I don't think that gets to the substance of what we're talking about here.
I agree.
But
I think everyone involved had plenty to drink, and
which is why we're here.
Right, and I think it's reasonable to assume that nobody's account is particularly credible, and it's unfortunate there were no witnesses.
So just to put out,
it's important to take into account that these men knew each other and were of a somewhat friendly past relationship, as I understand it. I don't think there was any, at least going into the night, it would be hard I don't think there's any evidence to support that there was any malicious intent going into the night. Not that that is relevant to the actual encounter, but.
Right, and to kind of go back to the actual sentencing here. So you mentioned 3rd degree assault with no jail time. I would like to put out here, just to put it on the table, as I mentioned, a felony conviction, as I'm sure you're aware, it kind of carries a certain weight to it.
So this will not be a felony conviction.
Oh, it won't? 3rd
degree assault in WCL state is a third degree is a misdemeanor.
Oh, perfect.
Yes.
Well, just that in mind, that could be a good meeting ground.
Yeah.
You mentioned that Mr. Young was apathetic at least to this whole thing. I know that WCL has a procedure, a nolle prosequi, where
Yes.
certain conditions are met. I don't know if there's anything, at least from his perspective, as the prosecuting party, that he could foreseeably. Is there anything he'd want? An apology? Anything that might fall under that we could just avoid?
Yeah. I wasn't sure exactly how this noli prosequi disposition would go. I don't know if you're more familiar with it in your past experience, but it's the major damage that the victim suffered was obviously the 20 stitches to his head, and he had to miss a week of work and a week's worth of pay. So if your client would maybe be, I can talk to Mr. Young. We hadn't discussed this, but if he would be willing to compensate him for his medical costs and time spent away from work, instead of pleading guilty to the misdemeanor, I think that's something we could discuss in the interest of the victim.
Absolutely. And just to fill you in, and I have the notes in front of me. It's essentially where the case is dismissed upon the fulfillment of agreed upon conditions is what we were getting into.
Right. Yeah, I'm reading into that. I'm just wondering, I don't want to cross any like ethical barriers by like promising something before talking to the client.
Of course. And that would have to, and this is all, we all go do our homework and ask our clients what they need. But
right.
that I think that's something I could certainly bring to the table. Given that there is money involved here, we've got medical costs.
Right. So I think that's I don't know how much time do we have left?
We have about 2.5 minutes.
Okay. So I think where it seems logical for us to end is we have two options here. And maybe you can go talk to your client and I can talk to mine and we can have a follow-up meeting. But we could either do the guilty plea to the third degree misdemeanor assault, or we could proceed with the nolle prosequi disposition with the presumption that the victim will be amenable to payment and compensation. And I'm going to consult with some colleagues, maybe some potential community service time would be appropriate as well. But
absolutely. And if you could give me a round number in terms of actual cost, what you're thinking of.
Cost.
I mean, this would be something you could consult with in terms of medical bills and stuff like that.
I will follow up. Yes, I'm not seeing any figure in my notes, so I'll have to consult with him.
Absolutely. And once I have that, I can bring it back to my clients, avoiding any conviction altogether. Subject to this condition, that would be the best case scenario on our end.
Right. And I think given that the victim seems a bit apathetic towards like punishing your client further, and just with the victim in mind, and then the also collateral consequences of having an additional charge on your client's record, I think that this is an equitable solution.
Great. I think this is a good place for us to kind of wrap up. We both have a place to go from here, and I'm sure we'll be in touch.
Yes. All right. Well, awesome.
All right. Thank you so much.
Thank you so much.